A common question that I'm sure a lot of people will have when they're considering bringing on someone new to their business is, am I going to lose any control as a result of bringing someone on new? And what are some ways that you might manage that?
Good question, Tony. And I guess that's firstly about each individual business will be different depending on what you're looking to achieve out of this. So if you are looking for a retirement in the next couple of years, then you might look at, you know, losing some control to allow someone else to sort of step up and step in. If you're looking at retaining key staff and particularly growing, then you'd probably want to maintain control. And there's various ways you can do that. And if we talk about, you know, we're bringing on someone as a shareholder, so we're talking about a company that the business is operating via. You've got directors and shareholder levels. So your directors basically manage day to day. And if you don't want to lose control, then you don't make the shareholder a director. So you maintain control of that day to day. If you did want to bring on someone as a director, then you look at implementing certain clauses in the shareholders agreement, providing that you're, say, the managing director or the controlling director, and dictating what decisions that you can just make off the bat and don't require any resolution of the board. But that can be discussed with your lawyer, and it's good to really go through and hash out exactly what you want to achieve, and then you can put that in the shareholders agreement. But bringing on a shareholder, they will have some equity, so it will dilute your equity, and that also dilutes your control somewhat. But it depends on the amount you're offering that shareholder, what really that would look like. So if it's only a 5% shareholding, then the minority shareholder really wouldn't have any control on voting rights, because you would always have a special resolution, which is 75%. And if you know, again, you would put in the shareholders agreement the decisions that would require special resolution, majority resolution. And the only other one is unanimous. So if you don't want any unanimous resolutions, you just don't put any of that in the shareholders agreement. But if you're looking at bringing on someone at more like 25%, then you need to think about, you know, what sort of control they may have and what sort of control you would want them to have. I guess the more shares that someone has, then maybe the more control that you would be prepared to offer, given that they are growing and you might see them as an equal partner in the future. So basically it depends on the situation, and you can really dictate that and dig deep down when drafting the shareholders agreement. And Sophie Amet sent through a few questions before this, and one of them goes towards this, and it's, how can a business owner manage equity dilution when making an employee a shareholder, and strategies and structures to maintain control and balance interests. So I guess equity dilution is just part and parcel of offering an employee shares, unless you want to structure it by offering a specific or special class of shares that don't attract voting rights and only attract dividends. That will still decrease your equity though, because you're obviously
paying dividends. Yep.
But that would, mean they have absolutely no control because they've got a special class of share that has no voting rights. So that's another option.
Yep.
And I think we probably covered Sophie's question in that.